What would you do if a cop cuffed you, skipped your rights, and tried to get you talking anyway? If you answer the wrong way, your own words can become the brick that builds the case against you. But if you know the exact move to make, you can shut down the questioning, protect your rights, and sometimes blow a giant hole in their whole case. Hit subscribe right now because what I'm about to show you could save you from talking yourself into jail. And like this video so you can find it fast when your brain goes blank during a real stop. Here's the reality. A lot of people think the magic moment is when a cop says those famous words from TV. You know the line. You have the right to remain silent. But your protection does not start with some movie scene in a dark room. Your protection starts with what you do the second a cop starts pushing you to talk. No, a skipped warning does not always erase every charge by itself, but it can block your statements, wreck the clean confession they wanted, and turn a strong case into a messy one. In this video, you're going to learn the one question that forces the moment into the open, the exact line that locks down your silence, the lawyer sentence that stops questioning cold, and the trap cops use when they act friendly after arrest. I've analyzed over 200 body cam videos, and you keep seeing the same mistake. People talk first, think later, and regret it forever. Now let's talk about why this matters so much to you. Most people have no idea that cops do not need to scream or threaten you to get what they want. They just need you relaxed enough to keep talking. That's it. You think you're being polite? You think you're clearing things up? You think one little sentence will make you look innocent. Then that one sentence gets twisted into motive, timing, knowledge, or guilt. Here's the reality. The danger is not just the arrest. The danger is the space right after it, when your stress is high, your mouth is moving, and your rights are hanging by a thread. This comes straight from Supreme Court rulings. If you do not clearly use your rights, courts may treat your silence like nothing and your words like gold. That is why you need lines so simple you can say them under pressure. The first move is forcing the arrest line into the open before you start explaining yourself. Let me show you exactly what I mean. You look at the officer and say this: "Officer, am I under arrest or am I free to leave?" Word for word. Memorize that line. You're not being rude. You're not arguing. You're making the officer choose. And that choice matters more than you think. Why does this work for you? Because a normal traffic stop and a real arrest are not the same thing. During a basic roadside stop, the courts have said Miranda usually does not kick in yet. That comes from Berghuis v. McCarty. In plain English, the court said a short roadside stop is different from a full arrest. So if you assume your rights should have been read the second lights hit your mirror, you can get burned. Your question forces clarity. If the officer says you are free to leave, you stop talking and leave. If the officer says you are under arrest, now the custody line is clear, and any questioning that follows matters in a much bigger way. Bad way. Most drivers say, "I'm not sure why you stopped me, but let me explain." Then they start handing over facts the officer did not even have yet. Good way. Smart drivers say, "Officer, am I under arrest or am I free to leave?" Then the whole moment gets defined before they give away anything. Watch what happens when you skip this. You think you're in a casual talk. The officer asks where you were, who you were with, why you looked nervous, why your story changed, why there is a bag in the back seat, why your phone was buzzing, why you took that route home. You answer because nobody read you anything yet, so you think none of it counts. That is how people walk themselves right into a case. Former police officers have confirmed this works because once you pin down the status, the whole conversation changes. You stop drifting into free information. Now watch what happens when you do it right. The officer has to either let you go or own the arrest. If you are free, you leave. If you are arrested, you do not fill the silence with useless words. You move to the next step with your rights locked in. Defense attorneys use this exact line in court because it helps show whether you are being questioned while in custody or just detained for a brief stop. And that matters a lot. Let me make this very simple for you. This tactic is not about winning a debate on the sidewalk. It is about stopping confusion before confusion destroys your rights. You are drawing a bright line. You're making the officer say what this is, and once that line is clear, your next words have power. Have you ever been hit with questions before a cop made it clear what was happening to you? Drop a comment below, because I want to know how many of you have seen this in real life. Here's the trick they don't want you knowing. Silence only protects you if you actually use it the right way. You cannot just sit there and hope the court reads your mind. You have to say the words out loud. Here's exactly what you say. "I am invoking my right to remain silent. I will not answer questions." Those exact words. Say them calmly, say them once, then stop talking. This is 100% legal, and it matters because of Miranda v. Arizona, Berghuis v. Thompkins, and Salinas v. Texas. In plain English, those cases tell you something huge. The police have to warn you before custodial questioning. But if you do not clearly say you are using your right to stay silent, courts may decide you never really used it at all. That sounds crazy, but that is how it works. You have to speak to claim silence. Yes, that sounds backwards. No, it is not fair, but it is real. Bad way. Most drivers say, I didn't do anything, I swear, and I can explain. Then the officer keeps asking, and every answer becomes another piece of evidence. Good way. Smart drivers say, I am invoking my right to remain silent. I will not answer questions. Then the officer has a much harder time pulling useful facts out of them. Legal experts agree this is your strongest protection because it is clear, short, and easy for a judge to understand later. You are not maybe asking, you are not hinting, you are not being cute, you are locking the door. That matters because cops are trained to keep a conversation alive. They may say, we can help you if you help us. They may say, this is your chance to tell your side. They may say, if you're innocent, now is the time. That is pressure. It sounds soft, but it is pressure. Watch what happens when you stay calm. The officer asks, so where were you before this? You answer with your line. The officer asks, why is your friend saying something different? You answer with your line. The officer says, we already know what happened. You answer with your line. Then you go quiet. Not angry quiet. Not dramatic quiet. Just done. This is 100% legal, and it is often the smartest thing you can do for your future self. Now here's the part people mess up. They think silence means they can keep chatting about everything except the crime. Wrong. If you are talking, you are talking. Small talk turns into timelines. Timelines turn into contradictions. Contradictions turn into guilt. I only had one beer. I was just there for a minute. I barely know him. Those sound harmless. They are not harmless. They are gifts. And if you're thinking, won't I look guilty if I do this? Listen to me. Looking cooperative does not protect you. Your rights protect you. Innocent people talk themselves into charges every day because stress makes them babble. Guilty people do it too. The law does not reward rambling. It rewards clear choices. So give one clear choice, use the line, then shut your mouth. Listen closely because this is critical. Staying silent is good. Asking for a lawyer is even stronger. Here's exactly what you say. I want a lawyer. I'm not answering questions without my lawyer. Word for word. Memorize that sentence too. Do not soften it. Do not say maybe. Do not say later. Do not say you think you might need one. Say you want a lawyer. Period. Why is this so powerful for you? Because Edwards v. Arizona says that when you clearly ask for a lawyer during custodial questioning, police are supposed to stop interrogating you until counsel is there. Unless you start the conversation again, that means you do not just get a little shield. You get a giant stop sign. This comes straight from Supreme Court rulings. Once you ask clearly, the game changes. Bad way. Most drivers say, do you think I need a lawyer? Then the officer says, no, keeps talking, and the questions keep rolling. Good way. Smart drivers say, I want a lawyer. I'm not answering questions without my lawyer. Then the officer is supposed to stop the interrogation. Defense attorneys use this exact line in court because weak words create strong excuses for the other side. Maybe I should talk to someone. That is weak. I think I need help. Also weak. Can I call a lawyer later? Weak again. Those lines leave room. Your job is to leave no room. Your job is to make the record clean. Clear request, clear silence, clear stop. And yes, you still need to stop talking after you ask. That part matters. If you say you want a lawyer, then keep chatting because the room feels awkward. You can reopen the door yourself. That is a disaster. The safest move is simple. Ask for the lawyer. Repeat the line if needed. Then say nothing else about the facts. Here is why that saves you. Police often want one clean sentence after arrest. Just one. I knew the stuff was in the car. I was only holding it for him. I panicked and ran. That is what they want. If you ask for counsel, you block the easiest road to that sentence. Former police officers have confirmed this works because once you stop the flow of words, there is less to work with, less to twist, and less to put in front of a jury. And before you worry about sounding difficult, remember this. A lawyer is not a confession. A lawyer is protection. If a cop acts offended because you asked, that tells you even more. Your rights matter most when somebody wants them gone. 90% of drivers don't know what's coming next. If you're still here, you're in the top 10%. Drop a comment saying, I'm still here, because this next part is where a lot of people lose everything. Now let's cover the sneakiest move of all. You use your rights. The officer nods, and then the friendly talk starts. This is where they say, off the record, help me understand. Or, between us, tell me what really happened. Or, I'm just trying to help you out. You need a line ready for that too. Here's exactly what you say. I'm not discussing my day. I want my lawyer. Or you say, I'm invoking my right to remain silent. Then stop. Same calm tone, same shut door. Why does this matter to you? Because Rhode Island v. Innis says interrogation is not just direct questions. It can also be words or actions police should know are likely to get you to incriminate yourself. In plain English, they do not have to end every sentence with a question mark to be interrogating you. And Missouri v. Seibert warns against the dirty trick of questioning first, warning later, then trying to get you to repeat it. Legal experts agree this is your strongest protection when the room gets fake-friendly after arrest. Bad way. Most drivers say, off the record, it was just a misunderstanding. Then there's no off the record, and that statement follows them into court. Good way. Smart drivers say, I'm not discussing my day, I want my lawyer. Then the soft trap dies right there. You also need to know one more thing. Some questions are routine: name, address, birth date, basic booking stuff. Courts have allowed some of that. That came up in Pennsylvania v. Muniz, so do not act shocked if they ask simple ID questions. But do not slide from ID into facts. What's your address is one thing. Whose bag was that is very different. You answer the basic booking info if required. You do not start telling your story. I've analyzed over 200 body cam videos, and this is where panic takes over. You feel the silence, you want to fill it, you think being nice will help. It usually hurts. Your job is not to entertain the room. Your job is to protect your case, your future, and your freedom. So let's tie this together in plain English for you. Miranda v. Arizona says if police want to question you while you are in custody, they have to warn you about your rights first. Berghuis v. Thompkins says you need to clearly say you're using your right to remain silent, or the court may treat your silence like no clear choice at all. Edwards v. Arizona says if you ask for a lawyer, questioning is supposed to stop until your lawyer is there. Berkham v. McCarty reminds you that not every roadside stop counts as custody, which is why your first question matters. And Missouri v. Seibert tells police they cannot play cute games by questioning you first and trying to clean it up later with a warning. Here's the reality. These cases do not mean every mistake by police makes the whole case vanish, but they do mean your words can get blocked, their pressure can collapse, and weak evidence can start falling apart when you use your rights the right way. Let me show you exactly how this plays out for you in real life. You get pulled over late at night. The officer says you rolled a stop sign. Then he keeps you there. Another unit shows up. They start asking where you were going, who owns the car, and why you look nervous. Then they ask you to step out. A few minutes later, you're in cuffs. The wrong way goes like this. You say, I didn't do anything, but I was at my friend's place, and yeah, that bag is mine, but I didn't know what was in it. Then you get nervous and keep talking. You say you only had one drink. You say you were just borrowing the car. You ask if you should have a lawyer, but you never clearly ask for one. Then at the station, they keep chatting. You think they are helping you. They are building the file. The right way looks completely different for you. At the first point where things get serious, you say, Officer, am I under arrest or am I free to leave? If you are free, you leave. If you're under arrest and questions start coming, you say, I'm invoking my right to remain silent. I will not answer questions. If they keep pushing, you say, I want a lawyer. I'm not answering questions without my lawyer. If they switch to friendly talk, you repeat, I'm not discussing my day. I want my lawyer. Then you stop. Now compare the outcomes for you. In the bad version, the officers get your timeline, your admissions, your guesses, your excuses, and your contradictions. In the good version, they get almost nothing from your mouth. That changes everything. Maybe they still charge you, maybe they do not. But either way, you did not hand them the rope to tie the knot. That is the win you are fighting for. Next video, I'm revealing what to say when cops claim they smell weed. Subscribe right now so you don't miss it, because that one gets people searched every single day. So remember this, if you ever find yourself in that moment. First, make the officer define the moment by asking if you are under arrest or free to leave. Second, if questioning starts while you are in custody, clearly say, I'm invoking my right to remain silent. Third, lock it down harder by saying, I want a lawyer. I'm not answering questions without my lawyer. Fourth, do not fall for the fake-friendly trap after arrest, because there is no such thing as off the record with police. You do not need a perfect speech. You need a few perfect lines. And if you can remember those lines, you give yourself real protection when it matters most. Hit subscribe so you catch that weed smell video next. Smash that like button if this just saved you from a future arrest. And drop a comment telling me which line you're memorizing first. Stay safe out there.